The three new criminal laws have come into force now. So we bid farewell to the 160-year-old Indian Penal Code and brace ourselves for the Bharatiya Nyaya Sanhita or the BNS. But is this new legal framework truly a step forward, or are we overlooking crucial aspects of our established system? Hello ladies and gentlemen, my name is Urvashi Chauhan and I welcome you to this limited series by Live Law on the three new criminal laws. The first part of this series is already out, and if you have not seen it, do check it out for a deeper understanding of the Bharatiya Sakshya Adhiniyam, which has replaced the Indian Evidence Act. Let us take a look at the Bharatiya Nyaya Sanhita as I break it down for you. Overall, there are 20 chapters under the BNS. It has been streamlined in a way that it will now consist of only 358 sections as compared to 511 sections in the Indian Penal Code. As a result, the major change is that the scheme and chronology of the sections has been changed. For example, murder, which was earlier defined under Section 302 of the IPC, is now under Section 101 of the BNS, though there is no change in its definition. Let us now take a quick scan through the major changes section-wise that have been introduced in the new Penal Code, the BNS. Starting with Chapter 1, that is the definitions. Earlier, these interpretation clauses could be found from Section 8 to 52A, but now have been brought under Section 2 of the BNS in an alphabetical order for easy reading. Some new changes can also be found in the definitions. For example, child has been defined to mean any person below the age of 18 years. The term documents includes electronics and digital record. The term transgender has been now defined. Further, BNS states that any reference to a year or month should be understood according to the Gregorian calendar. Coming to Chapter 2, which is about punishments. If you remember, the fines under the IPC were very low, typically between Rs 10 to 1000 rupees. Additionally, the punishments for many offences needed updating. Therefore, the terms of imprisonment for several offences have now been increased. Fines have been raised and mandatory minimum sentences have been introduced. Community service has been introduced as a new form of punishment for petty offences like non-appearance in response to a proclamation, attempt to commit suicide, to compel or restrain exercise of lawful power of public servant, petty theft, misconduct in public by a drunken person, defamation, etc. The punishment of imprisonment of life has been clearly defined as imprisonment for remainder of a person's natural life. Chapter 3 deals with general exceptions and Chapter 4 explains the concepts of abetment, criminal conspiracy and attempt. In this chapter, the inclusion of Section 48 is a noteworthy development extending jurisdiction of the BNS beyond national borders. This provision facilitates the prosecution of an individual who is not a subject of Indian law but abets or aids the offences committed within India. Next, the offences against women and children have been given precedence over the others. Also, the offences against women and children, which were earlier scattered, have been consolidated under Chapter 5 of the BNS. Under this chapter, Exception 2 to Section 63 of BNS provides that sexual intercourse or sexual acts by a man with his own wife, the wife not being less than 18 years of age, is not rape. Earlier, the age limit was 15 years. So marital rape is still not a crime, but the age of the wife for such an act to be considered rape has been reduced. Section 69 penalizes the act of sexual intercourse with a woman by deceitful means. It specifically mentions that if such an act is done by deceitful means or by making promise to marry a woman without any intention of fulfilling the same, it shall amount to rape. Strangely, the explanation to this section says that deceitful means shall include false promise of employment or promotion or marrying by suppressing identity. This provision, let me tell you, has sparkled some backlash for misogynist legislative presumption that women naturally consent for sexual intercourse in return for employment or promotion. Moving ahead, now Section 70 subsection 2 of BNS provides death penalty for gang rape of women under 18 years of age. Also, Section 76 about disrobing a woman and Section 77 about voyeurism has been made gender neutral. In the offences against children, the act of hiring, employing or engaging a child to commit an offence is made a punishable offence under Section 95, which entails punishment of imprisonment of minimum 7 years, extendable to 10 years. The IPC provided for offence of procuration of minor girl under the age of 18 years. Section 96 of BNS deals with offence of procuration of any child below the age of 18 years, irrespective of gender. Another change is that the word child is substituted for person in Section 99 of BNS. This defines the offence of buying child for the purpose of prostitution. The imprisonment prescribed is not less than 7 years, but which may extend to 14 years. Earlier, the prescribed imprisonment was 10 years. Let us now consider changes in Chapter 6 of the BNS, that is, offences against the human body. Culpable homicide not amounting to murder, which was earlier Section 304 of IPC, is now 104 of BNS. It now provides for statutory minimum punishment of 5 years. Earlier, there was no minimum punishment under IPC in this case. Another addition is that mob lynching has been made a punishable offence now. Mentioned under Section 103 of the BNS, it reads that when a group of 5 or more persons acting in concert commits murder on the ground of race, caste or community, sex, place of birth, language, personal belief or any other ground, each member of such group shall be punished with death or imprisonment for life and shall also be liable to fine. There is also a major change in the provision relating to causing death by negligence or the hit and run cases. Section 106 of the BNS penalizes causing death by negligence. Subsection 2 has been added, which says that anyone who causes death by rash and negligent driving and flees without reporting to the police or a magistrate shall be punished with up to 10 years of imprisonment and a fine. This provision actually led to nationwide protests by truck and taxi drivers who argue that accidents are unintentional and that they flee due to fear of violent mobs. They claim that the new rules will increase their stress and job insecurity. Drivers also point out that factors beyond their control, like poor visibility during fog, could lead to unfair imprisonment. As a result of the massive protests, this provision is kept in abeyance for the time being, that is, it has not come into force. In the same section, the BNS has carved out a special classification for doctors in relation to the punishment for causing death by medical negligence. While the Sanhita enhances the punishment for causing death by negligence to imprisonment up to 5 years, if such death is caused by a doctor, then the punishment is imprisonment up to 2 years. Next, let me tell you the new offence of organized crime has been added. Section 111 of the BNS defines it as any ongoing illegal activities such as kidnapping, robbery, vehicle theft, extortion, land grabbing, contract killing, economic offences, cyber crimes, drug trafficking, weapon trafficking, or human trafficking for prostitution or ransom. This can be done by an individual or a group, whether acting alone or as part of an organized crime syndicate. The crime involves using violence, threats, intimidation, coercion, or other unlawful means to gain direct or indirect material benefits, including financial gain. The next section, that is 112, has been added to penalize petty organized crime, such as the act of theft, snatching, cheating, unauthorized selling of tickets, unauthorized betting or gambling, selling of public examination question papers, or any other similar criminal act. The term of imprisonment and fine for Section 111 is much more as compared to that in Section 112. A major development brought about by the Criminal Law Amendment is addition of Terrorist Act under Section 113 of the BNS, which did not find a place in the IPC. The wider definition of the offence of Terrorist Act is given compared to the initial version of the bill which was introduced in August last year. As you know, we already have another law titled Unlawful Activities Prevention Act, or the UAPA, aimed at preventing unlawful activities and associations that pose a threat to India's sovereignty and integrity. Therefore, an explanation has been added in BNS which clarifies that an officer not below the rank of Superintendent of Police will now decide whether the case has to be registered under Section 113 of BNS or the UAPA. In the same chapter, a new provision, that is Section 117, subsection 3, has been introduced to provide stringent punishment for such acts of grievous hurt which result in persistent vegetative state or in permanent disability. It will attract higher punishment of rigorous imprisonment for a term which shall not be less than 10 years, but which may be extended to imprisonment for life. Coming to Chapter 7, that is offences against the state. First of all, let me tell you that the offence of sedition has been removed. For those of you who do not know, this section was asked to be kept in abeyance by the Supreme Court in 2022 as it felt that the provision was not aligned with the current social environment. BNS penalizes acts endangering the unity and integrity of India. While sedition criminalized acts against the government, the BNS replaces government with the word country. Aspects of sedition have been retained under Section 152 of BNS, which states that anyone who knowingly incites secession, rebellion, subversive activities or endangers India's sovereignty will be punished with life imprisonment or up to 7 years in prison and a fine. However, expressing disapproval of government actions to seek lawful change is not an offence. The offence of attempt to commit suicide has been deleted in the BNS. This brings the law in line with the Mental Healthcare Act of 2017. However, a new section, that is 226, has been added in the BNS Chapter 13 to punish those who attempt to commit suicide with the intent to compel or restrain the exercise of any lawful power by a public servant. Let us now move forward to Chapter 17, that is offences against property. Here, scope of aggravated theft has been widened. The domain of offence of theft has been expanded to include theft of vehicle, theft from vehicle, theft of government property, and theft of idol or icon from any place of worship. In Section 305 of the BNS, such thefts have been made punishable with punishment up to 7 years. Next, snatching has been added as a new offence, the punishment for which is imprisonment up to 3 years and fine. In cases of theft where the value of the stolen property is less than 5,000 rupees and a person is convicted for the first time, the BNS provides that the convict, upon return of the value of the property or restoration of the stolen property, will be punished with community service. Further, the offence of mischief in Section 324 of BNS has been expanded, and causing loss or damage to any property, including the property of government or local authority, has been made punishable offence with imprisonment extendable up to 1 year or fine. These are some of the major changes which can be found in the Bharatiya Nyaya Sanhita. Apart from this, it is pertinent to mention 2 more provisions here. First, we see that Section 377 of IPC has been deleted, but unnatural intercourse against men or bestiality are no longer offences under BNS. Yes, it is essential to note that in landmark ruling of Apex Court in Navdeep Singh Johar, a bench of 5 judges of the Supreme Court had partially struck down the Section 377 of IPC, which criminalized consensual carnal intercourse. However, forced intercourse with an adult male and bestiality, that is, sexual intercourse with animals, was an offence under the IPC. But the BNS has completely deleted the offence, implying that forcible carnal intercourse against a man and bestiality are no longer offences. The second important point is that in view of Apex Court's judgment in Joseph Shrine's case, the offence of adultery under the IPC was deleted. However, the BNS retains it as Section 84, which penalizes a man for enticing the wife of another man so that she may have intercourse with any person. So this was a brief overview of the substantive changes brought about by the Bharatiya Nyaya Sanhita. For deeper understanding, you can always refer to the Bare Act. There remains considerable confusion regarding the practical implications and implementation of these changes, especially with change in the age-old scheme and chronology of the sections. Well, it is only the test of time that will determine the success of the BNS or otherwise. Thank you for watching and stay tuned for the next video in this series, a similar explainer on the Bharatiya Nyaya Suraksha Sanhita, which has replaced the Code of Criminal Procedure.